Morning, I'm Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. You may call the first case.
Calling case number, 23013-905 N.I. Lynn Lane versus Michael Weathers et al.
Appearances, please.
Good morning, Your Honor. Matt Bates appearing on behalf of the plaintiff.
Judge Rick Plum on behalf of the defendant Wolverine.
Good morning, Judge Razvan Radulescu on behalf of defendant Weathers.
All right. This is the date and time set for plaintiff's motion to lift stay and schedule a status conference within 30 days. Was there any objections?
No objection, Judge.
Okay, all right. I'm going to grant your motion, so I will lift the stay. With regards to a status conference, if you can check your calendars for March the 3rd at 9:30 via Zoom, that is a Tuesday.
Works for me, Judge.
That works for me, Judge.
And me as well.
All right. Mr. Bates, your motion is granted. If you could submit an order that would also include the status conference date of March the 3rd, 2026 at 9:30 via Zoom.
All right, I will do that. I appreciate it, Judge.
All right, thanks so much. Have a good day.
You too.
Thank
Take
you, Your
care.
Honor.
Calling case number 25015-161 N.F. Jawad A. Shaw, M.D., P.C. et al. Versus Bassett Services, Inc. Gallagher Bassett Services, Inc.
Anyone here on the Jawad A. Shaw, MD, PC matter? We can pass over that one.
Calling case number 24002-128 CZ Khadijah Kamara versus Corktown Collision LLC et al.
Good morning, Your Honor. Adam Taub on behalf of Khadijah Kamara, the plaintiff.
All right.
Judge, this is plaintiff's motion for entry of judgment.
I've already read your motion, but I'm just curious. I didn't receive a response from the plaintiff, from the defense counsel. Have you had any contact with him?
I spoke with him yesterday, and I don't think he is going to respond.
Okay, so he's not appearing today then?
Yeah, that's correct.
Okay, all right. I've had an opportunity to view your motion. I'm going to grant your motion. I'm going to enter a judgment in the amount of $17,000. Anything else?
Well, Your Honor, we actually attached a judgment form. Did you want me to resubmit that?
I do.
Okay, I'll submit it in a few minutes.
All right, thank you.
Thank you.
Calling case number 25002-106 N.I. Ayana Storm Ferguson et al. Versus Member Select Insurance Company et al.
Anyone here on the Ayana Storm Ferguson matter? We can pass over that one.
Calling case number 24002-362 N.I. Ebony Rayford versus Joyce Poole.
Anyone here on the Ebony Rayford matter? Right, we can skip over that one.
Calling case number 25010-833 N.I. Robert Ingram versus Malika Malaikai et al.
Appearances, please.
Good morning, Your Honor. Fadi Toll on behalf of the plaintiff.
Good morning, Your Honor. John Seckler on behalf of defendants.
All right. Was there an objection to plaintiff's motion to amend the complaint to add a claim of UM/UIM against MEMIC?
No objection, Your Honor.
Okay. I'm going to grant your motion. Your amended complaint is to be filed within the next 7 days. I will also issue a new summons. That summons will expire in 56 days, so make sure that you serve MEMIC right away.
Will do. Thank you, Your Honor.
And
right.
Your Honor, just looking forward in this matter, we have a discovery cutoff of May 25th, 2026, and we're on track to presently. I don't know if it'd be prudent to get ahead of it for a potential adjournment now, or would that be something that you would like us to bring up later?
What I'm willing to do is I'm willing at this time to continue discovery to case evaluation that's currently scheduled for July the 20th. And then, once BMIC comes in, if there's some additional adjournments you need, then you'll have to file a motion or a stipulated, or, well, actually, you'll have to file a motion because you're already on track 2.
Certainly, I would assume that'd be something that would be in their hands, joining
Yes.
the case.
Yeah.
But certainly a little bit of breathing room and adjourning discovery through the date of case evaluation in July, I think would be prudent at this time.
All right, you may submit an order. Anything
Thank you
else?
so much.
Mhm.
That's
Nothing
it.
else?
Nothing further. Have a great weekend, everyone.
You do the same.
Calling case number 24015732 NI, Frederick McCauley versus Progressive Marathon Insurance Company et al.
Good morning, Your Honor. Elizabeth Nichols on behalf of the defendant.
All right, and this is a show cause hearing this morning,
Yes, as to two of plaintiff's medical providers.
Eastside Chiropractic and Brain Injury Diagnostic Center.
Yes,
All right, you've had no contact with them?
I have not.
Okay, and at this time, what is your request?
We'd like to set a show cause hearing for them to appear and explain why they failed to comply with these subpoenas and also in
thought-
order that they're required to produce
I
our requested
thought,
records.
I thought today was the show cause hearing. No?
Ah.
I mean, if it's not, then let me know.
I thought that today
Okay,
was,
the motion.
yes.
All right, I'll grant your motion for a show cause hearing. How far out would you like the hearing to be scheduled?
We could do 2 weeks.
2 weeks would be February 13th, 2026. And do you want a 9:30 or 10:30 time?
9:30.
9:30. Your motion is granted. Show cause hearing will be scheduled for February 13th, 2026 at 9:30 via Zoom. Just make sure your order includes the contact information to join Zoom.
Perfect. Thank you so much.
You're welcome. Have a good day.
You too.
Calling case number 24005373 NI, Abdullah Al Hasham versus Dardas, Salam Dardas et al.
Anyone here on the Al Hatcham matter? We can pass over that one.
Calling case number 23014-994 PD, United Churches Credit Union versus Christian Reminat.
Good morning, Your Honor.
Good morning.
Elizabeth Butler, P80956, for Plaintiff United Churches Credit Union.
All right, and this is your motion to reopen the case after bankruptcy?
Yes, Your Honor.
All right, and it's my understanding from your motion that bankruptcy matter was closed December the 18th, 2025. There was no response to your motion. I'm going to grant your motion. The matter will be reopened. It's my understanding that a default was entered back in 2024, correct?
Yes, Your Honor.
All right, so the case is reopened.
Thank
Anything
you, Your
else?
Honor. I will e-file that proposed order, and I have one more case, but I will wait until Madam Clerk calls it.
All right, thank you.
Calling case number 25005-514 NF, Suzanne Johnson versus John Hartman et al.
Anyone here on the Johnson matter? We can pass over that one.
Calling case number 25018-491 CH, Detroit Rental Fund 6 LLC versus Oswaldo Sanchez Lopez.
Good morning, Your Honor. Shant Norsigian, P77410 on behalf of the plaintiff.
And this is your motion for default judgment quieting title?
Yes, Your Honor. The subject property is commonly known as 9014 Fielding in Detroit, 48228. The defendant was served via personal service on December 6th of 2025. The clerk entered default on January 14th, 2026. I sent a copy of the default as well as this motion and the notice of hearing on January 20th of 2026. There's been no response from the defendant. We did not anticipate a response from the defendant. I'm asking for a judgment of quiet title, and this will be a final order in the matter, Your Honor.
All right, made the record reflect, I've had an opportunity to view your motion. This is defendant's motion for default judgment quieting title. This case was filed before the court on November the 20th, 2025 as a complaint for quiet title to property located at 9014 Fielding, Detroit, Michigan, 48228. Defendant was personally served. There was proof of service that was filed with the court. Defendant failed to file an answer to the complaint and default was entered on January the 14th, 2026. Since that time, defendant has failed to file an answer to the complaint or response to this motion. The court will grant your motion quieting title. You may submit an order.
Thank you, Your Honor. Have a nice weekend.
You do the same.
Calling case number 25019-397 CHC Brinkley Enterprise LLC versus HNY LLC.
Your Honor, Donald Rump appearing on behalf of the plaintiff P 39112.
All right, and Mr. Rump, this is your motion for entry of default judgment to quiet title?
Yes, it is, Your Honor. This property is 5203 Alter Road. The defendant was properly served pursuant to court rule. This motion was served pursuant to 2.603, and so was the default.
All right, may the record reflect, I've had an opportunity to view your motion. This matter was filed before the court on December the 8th, 2024 as a complaint for quiet title to property located at 5303 Alter Road, Detroit, Michigan, 48224. Defendant was served and proof of service was filed with the court. There was no response, no answer to the complaint. As a result, a default entered on January 27, 2026. Since that time, defendant has failed to file an answer to the complaint or a response to this motion. As such, the court will grant your motion quiet title if you'll submit an order.
Thank you, Your Honor.
You're welcome.
Calling case number 25002-080 CK Southwood Financial LLC versus Christian Collier.
Good morning, Your Honor. Thomas Duquette, P82958 on behalf of plaintiff.
All right, and this is your motion for entry of default judgment?
Correct.
All right, you may proceed.
Thank you, Your Honor. It's plaintiff's motion for entry of default judgments. This is a collection action on 3 unpaid student loan accounts. The loan documents which evidence defendant's obligation to plaintiff are attached to the complaint, which is attached to this motion as Exhibit A. The proof of service on defendant is attached as Exhibit B, and the default request entry and certificate of mailing are attached as Exhibit C. There's an affidavit which attests to the amount we're seeking as damages, which is $63,707.56. That's attached as Exhibit D. Based on all those things and everything else covered in the brief, we would ask the court to enter judgment in the total amount of $64,186.
May the record reflect, I've had an opportunity to view your motion. The court will grant your motion, enter default judgment in the amount of $64,186. You may submit an order.
We will do so. Thank you, Your Honor. Have a good weekend.
You do the same.
Calling case number 25007-054 NF PhysioFit Rehabilitation Services PLLC versus Michigan Automobile Insurance Placement Facility.
Good morning. Appearances, please.
Good morning, Your Honor. Gary Blumberg on behalf of the plaintiff, PhysioFit.
Good morning, Your Honor. Lauren Brzezinski on behalf of defendant Michigan Automobile Insurance Placement Facility.
All right, and this is the date and time scheduled for a show cause hearing?
It is, Your Honor. This was a show cause from 2 weeks ago, adjourned to today.
Okay.
Your Honor, so this is the show cause hearing against Nina Gunn. We were here 2 weeks ago. Counsel for Nina Gunn did appear, and the court adjourned this one time again to give her another opportunity to show up. We did serve the order again on her attorney. I will note, as we indicated when we were here 2 weeks ago, on that same morning, I was in another courtroom with Attorney Grove for Nina Gunn on her case. And when we left this courtroom, I did offer up a couple of dates for a deposition. Did not hear back. Her case was actually dismissed that morning for her failure to appear in that action. And we have received no communication or depositions at this point in time with Ms. Gunn.
Okay, so what are you asking from the court?
Yeah, so Your Honor, I would like her stricken as a witness. However, I understand it wasn't brief, so I will file a separate motion. At this point in time, I would just be looking for an order that Nina Gunn has failed to appear for the show cause hearing in violation of this court's orders.
Okay. Mr. Bloomberg?
Your Honor, what I see in the practice a lot of days is fast and loose with all of the rules as much as you can to get whatever relief you can get from one judge to go to another judge. This stuff goes on all the time. When the patient filed her case through Mr. Grove last year, counsel for the defense was well aware of the pendency of this action assigned to you. The rules require that this case, their case, get reassigned to this case, to the first judge. Neither one of them did anything about that because the defense is very comfortable proceeding in two cases to see what relief they can get in what court. In fact, the motion that you're hearing today is preliminary to a motion just filed for summary disposition saying Judge Cox, who should not have had the case, has granted the motion for summary disposition for her failure to cooperate in the other case. Now, number one, there's no proof of service of the show cause on Nina Gunn. That's a separate case. Justin Grove is an attorney in another case. I don't know Justin Grove's relationship with Nina Gunn. What an attorney is supposed to do, I know this very well. If there is a breakdown in the relationship between the attorney and a client, they are supposed to withdraw. They moved the court to withdraw. Instead, what counsel for Ms. Gunn did was let the motion to dismiss that was granted by Judge Cox go without response. So this whole file becomes a complete out-and-out mess by the failure to comply with rules of the court. Now, I don't know how the court can grant any relief on this show cause. And in the previous show cause, we did reply in the original show cause motion, we replied that another matter wasn't followed. And that is, how do you get to the point of show causing people for not appearing when you haven't done an address check with the U.S. Postal Service to determine whether or not the person lives in an address that they're being attempted to serve at? Never done then, never done now. No proof of service of your order of show cause on Nina Gunn. There is no rule that provides in the other case you can serve the attorney. Now, of course, if it was in this case, you could serve the attorney, not in the other case. So they're not entitled to any relief. I find the entire matter being one after another rules dodged in an attempt to get provider cases dismissed. And as the court is well aware and counsel is well aware, we're going to argue at the appropriate time that we are innocent parties under the present case law and not affected by these dismissals. Of course, counsel wants the witness stricken. Counsel, wants every bit of relief that counsel can get from Nina Gunn's failures. In the beginning, the alleged failures of Nina Gunn were attempts to serve her at her Faust address, knowing that she at that time did have a relationship with Mr. Grove and Mr. Grove was communicating with MAIPF. Instead, they didn't talk to Mr. Grove at that time about wanting the statement, wanting the things, whatever they wanted. What they did was they tried to serve her at her house, and her mom said she moved. Now, I bet dimes to dollars that she did not move, and it was a mom indicating that because they also know from the claim file that in 2025, she has a vehicle registered to her at that same Faust address. And substituted service should have been sought at the appropriate time if they could not get the cooperation otherwise at that Faust address. And substituted service or alternative service or whatever you want to call should have included tacking at that house. I don't know how you don't do that. Publication, which is meaningless but generally accepted as a proper method of doing it, and then sending it return receipt requested. We don't know what happened to the return receipt requested letters, if they were sent, and what the response was, whether they were accepted by, we don't know anything of that. So we're at a point right now where I don't anticipate and don't expect that the court's going to say, let's start over and figure out where Nina Gunn is. But I don't want any more relief granted in this case, because the other case is gone. No more relief unless they follow the rules. And they did not serve Nina Gunn or even attempt to serve Nina Gunn with your order of show cause, telling her to appear.
I think she appeared a couple of weeks ago, did she not?
Her attorney appeared on her behalf, Your Honor.
Okay.
Her attorney appeared, Your Honor, according to what I'm hearing, and that was on the motion the day that the case was dismissed that he didn't file a response to. But your order needs to be sent to her, not to an attorney in another case. He never appeared here.
Ms. Brzezinski, anything else?
Yeah, so unfortunately, a lot of things. One, I've notified this court and Judge Cox's court on multiple occasions and multiple motions about the other pending action. Ms. Gunn's attorney failed to identify it. I can appreciate that, but I have not hidden that there was any other type of a pending case in any of the courts. I did attempt to seek alternate service and plaintiff objected to it, saying I'm not entitled to alternate service. So we restarted the entire thing. I've been trying to depose her for a year in multiple different lawsuits. We restarted the whole thing all over again in an attempt to get her cooperation because she was filing a suit, she was proceeding. They've been on notice of everything as well as other provider actions that have been ongoing. I'm not allowed to contact Ms. Gunn. The fact that she has an attorney means I cannot attempt to contact her in any matter, whether it is a provider suit or her suit. We can't. So we have done what we can do under the rules of professional conduct, and I have given her attorney notice. He showed up representing her before this court 2 weeks ago. He indicated that he represented her. He understood that he was the one to produce her. He got the order again. There's no issue as to that. None of this has ever been really addressed, and we've done everything possible in multiple actions, including filing individual motions. I did not only file a motion to dismiss. I have filed every motion possible in this case to get her to attend. She has not. So I do take an issue with counsel saying we're essentially playing games. I'm not. I am jumping through every hoop in 4 different lawsuits to get this woman to appear who couldn't even complete an application and answer a letter sent from November of 2024. So we really have gone through everything possible to try to locate this individual and get her cooperation. And yeah, her case was dismissed. Whether or not her attorney chose to file a response really isn't an issue. In this case, it might be a separate issue for her in that case, but he showed up. He represented to this court and Judge Cox what was going on, and Judge Cox went through that. I'm not seeking a motion for summary or a motion to dismiss in this case on res judicata or anything. I'm seeking it on a separate basis, as I am with this exact issue here, that she needed to cooperate and appear. She didn't. I'm not even asking the court to strike her now. I am following procedure and filing a separate motion. All I'm asking is in order to reflect that she failed to appear today, and that's it.
All right. I'm going to grant your request. May the record reflect this matter was scheduled for a show cause hearing today at 9:30. It's now 9:54. Ms. Gunn failed to appear. Plaintiff has argued that she wasn't properly served. However, her attorney in her case did appear and indicated that he was representing her or he was appearing on her behalf. So I am going to indicate that she failed to appear for today's show cause hearing. I did notice that there is a motion for summary disposition that was filed by the defendant on January the 20th. Ms. Brzezinski, do you currently have a date for that hearing?
Your Honor, our date has been given as March 24th.
Okay, matter will be scheduled for March 24th, 2026. And was there a time?
12 o'clock, Your Honor.
At 12 noon. Anything else?
Nothing from defense, Your Honor.
Matters adjourned.
Thank you very much.
Calling case number 25012-844 PD, Michigan United Credit Union versus Meridian.
Good morning again, Your Honor. Elizabeth Butler, P80956 for plaintiff, Michigan United Credit Union.
All right, and this is your motion for default as to claim and delivery judgment, correct?
Yes, as to both defendants. I assume the court has read the motion. I'm happy to summarize or answer any questions.
I've had an opportunity to view the motion. Proof of service was filed with the court on October the 14th, 2025. There was no answer to the complaint as a result of default entered on November the 4th, 2025. Since that time, defendants have failed to file a response to this motion or an answer to the complaint. So I'm going to grant your motion for default. You may submit an order.
Thank you, Your Honor. I just want to clarify for the record that there will be two separate judgments because Defendant Gregory, we're seeking possession only plus court costs, and against Defendant Newvart, we're seeking possession and the breach of contract damages, and the proposed judgments will reflect the same.
Yes, and the proposed judgment amount is $36,225, correct?
That's the damages amount. The total is $36,521.10. That includes the court costs and statutory attorney fee, and the interest accrued to date of proposed judgment was $413.14.
Right, your motion is granted. You may submit two orders.
Thank you, Judge Smith, and thank you to your clerk. Have a wonderful day.
Thank you, you too. Does anyone have a motion that's ready to be called?
I do, Your Honor. Good morning.
Okay.
I'm here on Al Sham.
What is it?
Or Al Hashem, I'm sorry.
Oh, Hashem.
Abdullah Al Hashem versus I represent Dardis and Melly.
This calling case number 24005373 NI. Al Hatcham versus, is it Dardas?
Correct.
All right.
Good morning, Your Honor. For the record, Roger Thon on behalf of defendants Dardis and Melly. This is my motion to compel plaintiff's answers to discovery. Just by way of context, the reason we have a trial date in March, and the reason I have filed a discovery motion is because my clients were served so far late in the game. It was finally turned over to the insurance company. No defaults were ever entered. I finally filed an appearance and answer on behalf of my clients. This court was gracious enough to reopen discovery and issue a new scheduling order. Unfortunately, I'm still at square one. I'm still looking for written discovery. That's why I asked for these answers within 7 days. I have been given no opportunity to take the plaintiff's deposition. I have no authorization signed. I am not ready to go to trial in March. Needless to say, I will do my best at the station.
Why don't we do it one at a time? I'm going to grant your motion. Plaintiff is required to provide you with just outstanding discovery responses in 7 days.
Oh, excellent, Your Honor. Thank you.
All right. On the meantime, we'll see how it goes. And if it looks like you are going to file a motion to adjourn trial, then you need to file the motion and give me a reason why. And it sounds like you've got a whole lot of reasons.
Oh, yes. All right. All right. Thank you, Your Honor. You have a
You're
good
welcome.
nice weekend. Thank you.
Thank you, you too. Anyone else with a motion that's ready?
I'm ready, Your Honor. On Jawad Shaw, it's case number 25015.
If you could turn your camera on.
Yes, sorry, Judge.
There you go. This is case number 2501561NF, Jawad A. Shaw, MD-PC versus Gallagher Bassett Services, Inc.
Yes. Good morning, Your Honor. Danero Lazar on behalf of Jawad A. Shaw, MD-PC, Alliance Anesthesia, and Insight Surgical Hospital.
All right. You know, I had a chance to read this motion as well as the complaint. Are you sure you're serving the correct defendant? This is a provider PIP claim. I've never heard of Gallagher.
You're right, Your Honor. This is one of the first times I heard of Gallagher as well, but it is the proper entity. I spoke with my client. Yeah, this is actually one of the second time I think I've filed. I have another one in 37 District Court.
Okay.
Yeah, and I even attached to Exhibit C, if you see the business search, Gallagher Bassett Services, Inc. They do provide auto. I have an EOB. I should have attached the EOB as well.
Well, no, I saw this and I thought, what kind of case is this? And then I pulled up the complaint and I thought, this is a provider PIP claim. I have never seen this name as an insurer. So I just want to make sure that you're going in the right direction and you double check to make sure that this in fact is a insurance company.
Yeah. No, I have EOB.
We'll be wasting a lot of time on it.
Right. No, Your Honor. Yeah, I double checked. I filed hundreds of these, and this is the first time against Gallagher. But yeah.
Okay. All right. Well, I'm going to grant your motion. I'll reinstate the case. It's my understanding that the defendants were served. I'm not sure, did you provide the court with, was there a default entered?
No default has been entered, Your Honor. I do want to make an attempt to reach out, but my next move is to file a default, correct? If I
Okay,
don't
all
get
right.
any response, yeah.
Okay, just don't let it languish, because
Yes.
if there's no action on this case within 90 days, then you'll get a notice of lack of progress. So reach out. If you don't have any success, then I'll expect you to file a default and then eventually a motion for default judgment.
Absolutely.
All
Thank you
right,
so
but your
much,
motion
Judge.
is granted and the case will be reopened.
Excellent. Should I file an order to that effect?
Yes,
Excellent. Thank you, Judge. Have a great weekend.
you do the same.
Thank you.
Anyone else have a motion ready for 9:30? Good morning, Ms.
Good
Silver.
morning, Judge. How are you?
Good.
Good. I am here on USA Underwriters versus Gardner et al.
I do not see that case.
Oh, we have it noticed for, let me pull it up. We had a renotice a hearing for January 30th at 9:45. Maybe the court,
9:45. All right, can you give me the case number?
yes. 25-012191-CK.
That matter is before Judge Gibson.
Oh my goodness, I went to the wrong court. Okay,
Yeah,
I
you
clicked the
did.
wrong button. Thank you.